I'll be giving you the second part of the Bill of Rights, and if you're not subscribed to our channel, go ahead and hit that subscribe button and let's study together. Thank you.
Section 2, Article 3, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature, and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. To whom is it directed? Against the state, the right cannot be invoked against a private individual. The protection against unlawful searches and seizures applies to governmental action. Its origin and history clearly show that it was intended as a restraint upon the activities of sovereign authority and was not intended to be a limitation upon other than governmental agencies. As against such authority, it was the purpose of the Fourth Amendment to secure the citizen in the right of unmolested occupation of his dwelling and the possession of his property, subject to the right of seizure by process duly served, and that is in People versus Marty. Who may invoke this? The constitutional right against unreasonable searches and seizure is a personal right, invocable only by those whose rights have been infringed. It protects all persons, including aliens, that is, Ku Chi Gan versus Deportation Board, GR number L10280, 1963. A corporation is entitled to immunity under the Fourth Amendment against unreasonable searches and seizures. A corporation is, after all, an association of individuals under an assumed name and with its distinct legal entity. In organizing itself as a collective body, it waives no constitutional immunities appropriate to such body. What is the concept of privacy? The zones of privacy are recognized and protected in our laws. Within these zones, any form of intrusion is impermissible unless excused by law and is in accordance with customary legal process. The Constitution does not have a specific provision protecting the right to privacy. It is a penumbral right formed from the shadows created by several constitutional provisions. That is to say, the right to privacy is located within the zones created by various provisions of the Constitution and various statutes which protect aspects of privacy. That is in Opal versus Torres, DR 127-683, 1998. What is the essence of privacy? The right to be left alone. In context, the right to privacy means the right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's ordinary sensibilities. Differentiate search warrant versus warrant of arrest. Under search warrant, as to authority which examines, the judge must personally examine in the form of searching questions and answers in writing and under oath the complainant and the witnesses he may produce on facts personally known to him. Under warrant of arrest, it is not necessary that the judge should personally examine the complainant and his witnesses. The judge would simply personally review the initial determination of the prosecutor to see if it is supported by substantial evidence. On the basis of determination on search warrant, the determination on probable cause depends on a large extent upon the finding or opinion of the judge who conducted the required examination of the applicant and the witnesses. Under a warrant of arrest, he merely determines the probability, not the certainty, of guilt of the accused, and in so doing, he need not conduct a new hearing. Requisites for a valid warrant. 1. It must be issued upon determination of probable cause. 2. The probable cause must be determined by the judge himself and not by the applicant or any other person. Number 3, in the determination of probable cause, the judge must examine under oath or affirmation the complainant and such witnesses as the latter may produce. And fourth, the warrant issued must particularly describe the place to be searched and persons and things to be seized. HPS Software and Communication Corporation and YAP versus PLDT, dear numbers 170217 and 170694, December 10, 2012. Note, however, that the general warrant is not allowed. It must be issued pursuant to a specific offense. Stonehill versus Ducno, GR L 19550 to 1967. General warrants. Warrants of broad and general characterization or sweeping descriptions which will authorize police officers to undertake a fishing expedition to seize and confiscate any and all kinds of evidence or articles relating to an offense. The purpose of particularity of description in search warrants is 1. Readily identify the properties to be seized and thus prevent the peace officers from seizing the wrong items, and number 2, leave peace officers with no discretion regarding the articles to be seized and thus prevent unreasonable searches and seizures. Bashin Ku versus Ruiz 37 Scra 823, February 27, 1971. Particularity of description for a search warrant is complied with when 1. The description therein is as specific as the circumstances will ordinarily allow, or 2. The description expresses a conclusion of fact, not of law, by which the warrant officer may be guided in making the search and seizure, or 3. The things described are limited to those which bear direct relation to the offense for which the warrant is being issued. Properties subject to seizure. 1. Property subject of the offense. 2. Stolen or embezzled property and other proceeds or fruits of the offense. Or 3. Property used or intended to be used as means for the commission of an offense. Note: seized items in violation of Article 201 of the RPC, such as immoral doctrines, obscene publications, and indecent shows, can be destroyed even if the accused was acquitted. PD number 969, an act amending Article 201, mandates the forfeiture and destruction of pornographic materials involved in the violation of Article 201 of the Revised Penal Code, even if the accused was acquitted, and that is found in the case of Nogales versus People, GR number 191080, November 21, 2011. What is the nature of search warrant proceedings? Neither a criminal action nor a commencement of a prosecution. It is solely for the possession of personal property. United Laboratories Inc. versus ESIP, GR 163858, June 28, 2005. Probable cause. How to determine. Probable cause as a condition for the issuance of a search warrant is such reasons supported by facts and circumstances as will warrant a cautious man to believe that his action and the means taken in prosecuting it are legally just and proper. It requires facts and circumstances that would lead a reasonable, prudent man to believe that an offense has been committed and that the objects sought in connection with that offense are in the place to be searched. HPS Software and Communication Corporation and YAP versus PLDT, GR numbers 170, 217, and 170, 694. Such facts and circumstances antecedent to the issuance of a warrant that in themselves are sufficient to induce a cautious man to rely on them and act in pursuance thereof. The evidence necessary to establish probable cause is based only on the likelihood or probability of guilt. Estrada versus Office of the Ombudsman. Question: LPG Dealers Association and Total Gas LPG Dealers Association filed a letter complaint before the NBIIRO requesting assistance in the surveillance, investigation, apprehension, and prosecution of respondents for alleged illegal trading of LPG products and or underfilling, possession, and or sale of underfilled LPG products. The NBI IRO, through its agent De Hamil and undercover NBI Asset Antonio, conducted surveillance and test by operation, and thereafter they filed two applications for search warrant to conduct a search of the Magsingal LPG refilling plant. Can the personal knowledge of the witnesses of the commission of the illegal trading and underfilling of LPG products be a basis for determining probable cause in search warrant applications? Yes. A finding of probable cause needs only to rest on evidence showing that more likely than not, a crime has been committed and that it was committed by the accused. Probable cause demands more than bare suspicion. It requires less than evidence which would justify conviction. The judge, in determining probable cause, is to consider the totality of the circumstances made known to him, and not by a fixed and rigid formula, and must employ a flexible totality of the circumstances standard. Facts discovered during surveillance on the basis of information and evidence provided by petitioners constitute personal knowledge which could form the basis for the issuance of a search warrant. Petron LPG Dealers Association versus Ang, GR number 199371, February 3, 2016. What is personal knowledge? The person to be arrested must execute an overt act indicating that he had just committed, or actually committing, or is attempting to commit a crime, and 2. Such overt act is done in the presence or within the view of the arresting officer. Note, initial hearsay information or tips from confidential informants could very well serve as basis for the issuance of a search warrant if followed up personally by the recipient and validated. Looking at the records, it is clear that Padilla and his companions were able to personally verify the tip of their informant. The evidence on record clearly shows that the applicant and witnesses were able to verify the information obtained from their confidential source. The evidence likewise shows that there was probable cause for the issuance of a search warrant. Thus, the requirement of personal knowledge of the applicant and witnesses was clearly satisfied in this case. Microsoft Corporation versus Samir Farah, GR 205-800, September 10, 2014. Mere reliable information will not satisfy the personal knowledge requirement. The long-standing rule in this jurisdiction, applied with a great degree of consistency, is that reliable information alone is not sufficient to justify a warrantless arrest under Section 5, letter A of Rule 113. The rule requires, in addition, that the accused perform some overt act that would indicate that he has committed, is actually committing, or is attempting to commit an offense. In the leading case of People versus Burgos, this court held that the officer arresting a person who has just committed, is committing, or is about to commit an offense must have personal knowledge of that fact. The offense must also be committed in his presence or within his view. In Burgos, the authorities obtained information that the accused had forcibly recruited one Cesar Masamlok as member of the New People's Army, threatening the latter with a firearm. Upon finding the accused, the arresting team searched his house and discovered a gun, as well as purportedly subversive documents. People versus Tutut, GR 144037, September 26, 2003. Searching questions. Examination by the investigating judge of the complainant and the latter's witnesses in writing and under oath or affirmation to determine whether there is a reasonable ground to believe that an offense has been committed and whether the accused is probably guilty thereof, so that a warrant of arrest may be issued and he may be held liable for trial. A police officer cannot amplify or modify what has been set out in the warrant. Such a change is prescribed by the Constitution, which requires a search warrant to particularly describe the place to be searched. Otherwise, it would open the door to abuse of the search process and grant the officers executing the search the discretion which the Constitution has precisely removed from them. The particularization of the description of the place to be searched may properly be done only by the judge and only in the warrant itself. It cannot be left to the discretion of the police officers conducting the search. It is neither fair nor licit to allow police officers to search a place different from that stated in the warrant on the claim that the place actually searched, although not that specified in the warrant, is exactly what they had in view when they had applied for the warrant and had demarcated in their supporting evidence. What is material in determining the validity of a search is the place stated in the warrant itself, not what applicants had in their thoughts or had represented, and the proof they submitted to the court issuing the warrant. People v. CA 291 SQA 400. Question: Nenita and Julianne were graduating high school students at St. Teresa's College, STC, Cebu City. While changing into their swimsuits for a beach party they were about to attend, Julia and Julianne, along with several others, took digital pictures of themselves clad only in their undergarments. These pictures were then uploaded by Angela on her Facebook profile. Back at the school, Escudero, a computer teacher at STC's high school department, learned from her students that some seniors at STC posted pictures online depicting themselves from the waist up, dressed only in brassieres. Escudero reported the matter and through one of her students' Facebook page showed the photos to Tigol, STC's discipline in charge for appropriate action. Were the means in gathering information about the photos unlawful? No. Even assuming that the photos in issue are visible only to the sanctioned students' Facebook friends, respondent STC can hardly be taken to task for the perceived privacy invasion since it was the minors' Facebook friends who showed the pictures to Tigol. Respondents were mere recipients of what were posted. They did not resort to any unlawful means of gathering the information as it was voluntarily given to them by persons who had legitimate access to the said posts. Clearly, the fault, if any, lies with the friends of the minors. Curiously enough, however, neither the minors nor their parents imputed any violation of privacy against the students who showed the images to Escudero. Vivares versus St. Teresa's College. Question: PNP constituted a team to implement a search warrant issued by the judge to search Edmund Bulaitan's residence. Before going to the target residence, the search team first went to the house of the barangay chairman, who in turn assigned Kagawad Jerry and Kagawad Harold as search witnesses. Upon arriving at Bulaitan's residence, the search team was met by Bulaitan's two children and housekeeper, who informed them that Bulaitan was not home. This notwithstanding, the search team explained to the children and housekeeper the reason for their presence, prompting the latter to allow them inside the house and conduct search. SPO Bakay then proceeded to Baloitan's room and there discovered 3 heat-sealed plastic sachets containing white crystalline substance, which was later on confirmed as shabu. Based on the testimonies, it was discovered that A. Bulaitan was not in his residence when the search was conducted. B. His daughter, Maria, was not able to witness. SPO Bakay's search of Bulaitan's room as PO3 Tagal kept her in the living room and even instructed her to leave the house to contact her parents. And C. Kagawad Jerry and Kagawad Harold neither witnessed the search as they remained outside Bulaitan's residence. The RTC finds Bulaitan guilty and was affirmed by the CA. Should the CA uphold the decision? No. Section 8, Rule 126, Search of house, room, or premises to be made in presence of 2 witnesses, provides that a search under the strength of a warrant is required to be witnessed by a lawful occupant of the premises sought to be searched. It must be stressed that it is only upon their absence that their presence may be replaced by two persons of sufficient age and discretion residing in the same locality. In this case, a judicious perusal of the records reveals that the policeman involved in the search of Bulaitan's residence, as shown in their own testimonies, did not conduct the search in accordance with Section 8, Rule 126 of the Revised Rules of Criminal Procedure. Worse, the search team even instructed Maria to contact her father via telephone, which she could only do by leaving their residence and going to the house of a certain Dr. Romero Bago to use the telephone therein. It was only after her return to their residence that SPO2 Bakay announced that they have allegedly found Shabu in Bulaitan's room. The search conducted therein by the search team fell way below the standard mandate by Section 8, Rule 126 of the Revised Rules of Criminal Procedures, and thus deemed unreasonable within the purview of the exclusionary rule of the 1987 Constitution. Edmund Bulaitan E. Mawayan versus People of the Philippines, GR 218891, September 19, 2016. What happens in the absence of the required witnesses? The absence of the required witnesses does not per se render the confiscated items inadmissible. However, a justifiable reason for such failure or a showing of any genuine and sufficient effort to secure the required witnesses must therefore be adduced. In this case, while the inventory and the photography of the seized items were made in the presence of Ferriol and an elected public official, the records do not show that the said inventory and photography were done before any representative from the DOJ and the media. Hence, the court is impelled to conclude that the integrity and evidentiary value of the items purportedly seized from Ferriol, which constitute the corpus delicti of the crimes charged, have been compromised. People of the Philippines versus Benjamin Ferriol E. Perez, GR 232554, August 20, 2018. An error in the name of the person in the search warrant does not invalidate the warrant as long as it contains a description personae, including additional descriptions that will enable the officer to identify the accused without difficulty. Nala versus Barroso Jr. Supra. Search warrant is valid despite the mistake in the name of the person to be searched. The authorities will conduct surveillance and test spy operations before obtaining the search warrant and subsequently implementing it. They had personal knowledge of the identity of the persons and the place to be searched, although they did not specifically know the names of the accused. People versus TU1 Chua GR 149878. A John Doe search warrant is valid. There is nothing to prevent issue and service of warrant against a party whose name is unknown. People versus Veloso. The warrant must refer to one specific offense. However, the rule is not violated if the offenses are closely related or under the same category. For example, in Piper versus Di Coso, GR numbers 10126-18, which involves the violation of the Dangerous Drug Act, the defense theorized that 3 separate search warrants should have been issued instead of one, the first for illegal possession of shabu, the second for illegal possession of marijuana, and the third for illegal possession of paraphernalia. The court ruled that the Dangerous Drugs Act of 1972 is a special law that deals specifically with dangerous drugs which are subsumed into prohibited and regulated drugs and defines and penalizes categories of offenses which are closely related or which belong to the same class or species. Accordingly, one search warrant may thus be validly issued for the said violation of the Dangerous Drugs Act. Warrantless searches and seizures. Instances of a valid warrantless search. 1. Visual search, which is made of moving vehicles at checkpoints. 2. Search in an incident to a valid arrest. Note, an officer making an arrest may take from the person any money or property found upon his person which was used in the commission of the offense, the fruits thereof, which might furnish the prisoner with the means of committing violence or escaping, which might be used as evidence in the trial of the case. Number 3, search of passengers made in airports. 4, when things seized are within plain view of a searching party, or we call it the plain view doctrine. 5th, stop and frisk usually precedes an arrest. Number 6, when there is a valid express waiver made voluntarily and intelligently. Note, consent to a search is not to be lightly inferred, but shown by clear and convincing evidence. Consent must also be voluntary in order to validate an otherwise illegal search. That is, the consent must be unequivocal, specific, intelligently given, and uncontaminated by any duress or coercion. Cabalis versus CA, 2015, bar. In this case, petitioner was merely ordered to take out the contents of his pockets. Alcaraz versus People, GR 199042, November 17, 2014. Now, number 7 is custom search, and number 8, exigent and emergency circumstances. Plain view doctrine. Under the plain view doctrine, objects falling in the plain view of an officer who has a right to be in that position to have that view are subject to seizure and may be presented as evidence. It applies when the following requisites concur. We have the J.I.A. J is the law enforcement officer in search of the evidence has a prior justification for an intrusion or is in a position from which he can view a particular area. Number 2, the discovery of the evidence in plain view is inadvertent. And 3, it is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise subject to seizure. The law enforcement officer must lawfully make an initial intrusion or properly be in a position from which he can particularly view the area. In the course of such lawful intrusion, he came inadvertently across a piece of evidence incriminating the accused. The object must be open to eye and hand, and its discovery inadvertent. Fajardo versus People, GR 190889. Note, plain view doctrine cannot be applied where there was no evidence in plain view of law enforcers serving the search warrant. United Laboratories Inc. versus EC. Question. Quino, a drug pusher, was entrapped in a body bus operation. He led the police officers to the house of Carlo Ray, his supposed associate, and his house was searched. A cardboard box with bricks of marijuana inside was found in her residence. However, Carlo Ray's warrantless arrest was declared illegal by the court. It follows that the search of his persons and home and the subsequent seizure of the marked bills and marijuana cannot be deemed legal as an incident to her arrest. Was the marijuana in the cardboard box in plain view during the search, making the warrantless seizure valid and acceptable in evidence? The answer is no. The law enforcement officer must lawfully make an initial intrusion or properly be in a position from which he can particularly view the area. In the course of such lawful intrusion, he came inadvertently across a piece of evidence incriminating the accused. The object must be open to eye and hand, and its discovery inadvertent. It is clear that an object is in plain view if the object itself is plainly exposed to sight. The difficulty arises when the object is inside a closed container, where the object seized was inside a closed package. The object itself is not in plain view and therefore cannot be seized without a warrant. However, if the package proclaims its contents, whether by its distinctive configuration, its transparency, or if its contents are obvious to an observer, then the contents are in plain view and may be seized. People versus Doria. GR number 125299. Stop and frisk search. Limited protective search of outer clothing for weapons. Probable cause is not required, but a genuine reason must exist in light of a police officer's experience and surrounding conditions to warrant the belief that the person detained has weapons concealed. Malakat versus CA. Checkpoints. Searches conducted in checkpoints are lawful, provided the checkpoint complies with the following requisites. 1. The establishment of checkpoint must be pronounced. Number 2. It must be stationary, not roaming. And 3. The search must be limited to visual search and must not be an intrusive search. Note, not all searches and seizures are prohibited. Between the inherent right of the state to protect its existence and promote public welfare and an individual's right against warrantless search, which is, however, reasonably conducted, the former should prevail. A checkpoint is akin to a stop-and-frisk situation whose object is either to determine the identity of suspicious individuals or to maintain the status quo momentarily while the police officers seek to obtain more information. Belmonte versus De Villa, GR number 83988, September 29, 1989. Motorists and their vehicles passing through checkpoints may also be stopped and extensively searched. While, as a rule, motorists and their vehicles passing through checkpoints may only be subjected to a routine inspection, vehicles may be stopped and extensively searched when there is a probable cause which justifies a reasonable belief among those at the checkpoints that either the motorist is a law offender or the contents of the vehicle are or have been instruments of some offense. People versus Vinicario, GR 141137. Checkpoints rules under LTO Code, RA 4136. There is, to stress, nothing in RA 4136 that authorized the checkpoint manning policeman to order petitioner and his companions to get out of the vehicle for a vehicle and body search. And it bears to emphasize that there was no reasonable suspicion of the occurrence of a crime that would allow what jurisprudence referred to as stop-and-frisk action. As SPO for Budino no less testified, the only reason why they asked petitioner to get out of the vehicle was not because he has committed a crime, but because of their intention to invite him to Station 9 so he could rest before he resumes driving. But instead of a tactful invitation, the apprehending officers, in an act indicative of overstepping of their duties, dragged the petitioner out of the vehicle and in the process of subduing him, pointed a gun and punched him on the face. None of the police officers, to note, categorically denied the petitioner's allegation about being physically hurt before being brought to the hospital ng Maynila to be tested for intoxication. What the policemen claimed was that it took the three of them to subdue the 55-year-old petitioner. Both actions were done in excess of their authority granted under RA 4136. Sideco versus People, November 12, 2014. Question. Star was a lady frisker whose duty is to frisk department passengers, employees and crew and check for weapons, bombs, prohibited drugs, contraband, goods, and explosives. When she frisked Rochelle, a boarding passenger, she felt something hard on Rochelle's abdominal area, which was later found to be 3 packs of shabu. Can Rochelle invoke a violation of the search and seizure clause? The answer is no. Persons may lose the protection of the search and seizure clause by exposure of their persons or property to the public in a manner reflecting a lack of subjective expectation of privacy, which expectation society is prepared to recognize as reasonable. Such recognition is implicit in airport security procedures, with increased concern over airplane hijacking and terrorism has come increased security at the nation's airport. People versus Layla Johnson, Tier 138881, December 18, 2000. Question. Luz was flagged down by PO3 Altesa for driving a motorcycle without a helmet. Altesa invited Luz to their substation and while issuing a citation ticket for violation of municipal ordinance, Altiza was alerted by the latter's uneasy movement and asked him to put out the contents of the pocket of his jacket. It was revealed that Luz was in possession of prohibited drugs. Can the roadside questioning of a motorist detained pursuant to a routine traffic stop be considered a formal arrest? The answer is no. The time he was waiting for Altiza to write his citation ticket may be characterized as waiting time. Luz could not be said to have been under arrest. There was no intention on the part of Altiza to arrest him, deprive him of his liberty, or to take him into custody. In fact, Altiza himself testified that it was only for the sake of convenience that they were waiting at the substation. Luz versus People of the Philippines, GR 197788. Question. A search was conducted on March 3, 1986, during which the Philippines has no constitution. The constabulary raiding team searched the house of Elizabeth Di Maano by virtue of a search warrant and thereafter seized some items not included in the warrant. Di Maano questioned the search for being violative of the Constitution. Can she invoke her right against unreasonable searches and seizure during the interregnum? Yes. The Bill of Rights under the 1973 Constitution was not operative during the interregnum. Be that as it may, under Article 17, Number 1 of the International Covenant on Civil and Political Rights, the revolutionary government had a duty to ensure that no one shall be subjected to arbitrary or unlawful inference with his privacy, family, home, or correspondence. Article 17, Number 2 provides that no one shall be arbitrarily deprived of his property. Although the signatories to the declaration did not intend it as a legally binding document, being only a declaration, the court has interpreted the declaration as part of the generally accepted principles of international law and binding on the state. The revolutionary government did not repudiate the covenant or the declaration during the interregnum. It was also obligated under the international law to observe the rights of individuals under the declaration. Republic versus Sandigan Bayan, July 21, 2003. Question. While sleeping in his room, Kel was arrested by virtue of a warrant of arrest, and he was dragged out of the room. Thereafter, some police officers ransacked the locked cabinet inside the room, where they found a firearm and ammunition. Is the warrantless search and seizure of the firearm and ammunition justified as an incident to a lawful arrest? The answer is no. The scope of the warrantless search is not without limitations. A valid arrest allows the seizure of evidence or dangerous weapons either on the person of the one arrested or within the area of his immediate control. The purpose of the exception is to protect the arresting officer from being harmed by the person arrested, who might be armed with a concealed weapon, and to prevent the latter from destroying evidence within reach. In this case, search was made in the locked cabinet, which cannot be said to have been within Kel's immediate control. Thus, the search exceeded the bounds of what may be considered as an incident to a lawful arrest. Valerio versus CA, GR 164815, September 3, 2009. Question. A buy-bust operation was conducted in DM's store. Police officer C.A. Tandok posed as a buyer and bought marijuana from DM. After the exchange of marked money and marijuana, Tandok arrested DM without a warrant. The other police officer searched the store and seized a plastic container containing 6 marijuana stalks. Thereafter, DM was charged with selling marijuana. Is the warrantless seizure of marijuana legal? Yes. The search being an incident to a lawful arrest, it needed no warrant for its validity. The accused having been caught in flagrante delicto, the arresting officer were duty-bound to apprehend her immediately. The warrantless search and seizure as an incident to a lawful arrest may extend to include the premises under the immediate control of the accused. The accused may not successfully invoke the right against a warrantless search even as regards the plastic container with dried marijuana leaves found on the table On her table, People versus Salazar. I'm sorry, I'm really confused if this is a his or her. They use both. Question: Sergeant Victorino Nocija and Sergeant Alex de Castro, while on a routine patrol in Pangasinan Laguna, spotted a passenger jeep unusually covered with cacahuate leaves. Suspecting that the jeep was loaded with smuggled goods, the two police officers flagged down the vehicle driven by Rudy. The police officers then checked the cargo and they discovered bundles of 3.8 millimeter aluminum or galvanized conductor wires exclusively owned by National Power Corporation. Police officers took Rudy into custody and seized the conductor wires. Was Rudy's right against unreasonable searches and seizures violated when the police officers searched his vehicle and seized the wires found therein without a search warrant? The answer is yes. When a vehicle is stopped and subjected to an extensive search, such a warrantless search would be constitutionally permissible only if the officer conducting the search have reasonable or probable cause to believe before the search that either the motorist is a law offender or they will find the instrumentality or evidence pertaining to a crime in the vehicle to be searched. However, the fact that the vehicle looks suspicious simply because it is not common for such to be covered with cacahuate leaves does not constitute probable cause as would justify the conduct of a search without a warrant. Furthermore, the police authorities did not claim to have received any confidential report or tipped information that Rudy was carrying stolen cable wires in his vehicle, which could otherwise have sustained their suspicion. It cannot likewise be said that the cable wires found in Rudy's vehicle were in plain view, making its warrantless seizure valid. The cable wires were not exposed to sight because they were placed in sacks and covered with leaves. The articles were neither transparent nor immediately apparent to the police authorities. Cabalis versus CA. Question: A police officer flagged down a rider for driving without a helmet. The police officer invited the rider to come inside their substation located near the area. While issuing a citation ticket for violation of a municipal ordinance, the police officer noticed that the accused was uneasy and kept on reaching something from his jacket. He then asked the rider to take out the contents of his jacket, and it turned out the rider has in his possession 2 plastic sachets of suspected shabu. The RTC convicted him of illegal possession of dangerous drugs since he had been lawfully arrested for a traffic violation and then subjected to a valid search, which led to the discovery on his person of 2 plastic sachets of shabu. On appeal, the CA affirmed the RTC's decision. In his appeal to the Supreme Court, the writer claims that there was no lawful search and seizure because there was no lawful arrest since he was not even issued a citation ticket or charged with violation of the city ordinance. Even assuming that there was a valid arrest, he claims that he had never consented to the search conducted upon him. Should the writer appellant's contention be upheld? The answer is yes. There was no valid arrest of appellant. When he was flagged down for committing a traffic violation, he was not ipso facto and solely for his reason arrested. Arrest is the taking of a person into custody in order that he or she may be bound to answer for the commission of an offense. It is effected by an actual restraint of the person to be arrested, or by the person's voluntary submission to the custody of one making the arrest. Neither the application of actual force, manual touching of the body, or physical restraint, nor a formal declaration of arrest is required. It is enough that there be an intention on the part of one of the parties to arrest and the other, and that there be an intent on the part of the other to submit, under the belief and impression that submission is necessary. At the time that he was waiting for the police officer to write his citation ticket, appellant could not be said to have been under arrest. There was no intention on the part of the former to arrest him, deprive him of his liberty, or take him into custody. Prior to the issuance of the ticket, the period during which appellant was at the police station may be characterized merely as waiting time. In fact, as found by the trial court, the only reason they went to the police substation was the appellant had been flagged down almost in front of that place. Hence, it was only for the sake of convenience that they were waiting there. There was no intention to take him into custody. It also appears that according to City Ordinance number 98-012, which was violated by the appellant, the failure to wear a helmet while riding a motorcycle is penalized by a fine only. Under the rules of court, a warrant of arrest need not be issued if the information or charge was filed for an offense penalized by a fine only. It may be stated as a corollary that neither can a warrantless arrest be made for such an offense. There being no valid arrest, the warrantless search that resulted from it was likewise illegal. Rodel, Luz versus People. Waiver of unlawful arrest and illegal searches. A waiver of an illegal arrest, however, is not a waiver of an illegal search. Records have established that both the arrest and the search were made without a warrant. While the accused has already waived his right to contest the legality of his arrest, he is not deemed to have equally waived his right to contest the legality of the search. Alcaraz versus People. Administrative arrest. There is an administrative arrest when there is an arrest as an incident to a deportation proceeding. The following aliens shall be arrested upon the warrant of the Commissioner of Immigration or of any other officer designated by him for the purpose and deported upon the warrant of the Commissioner of Immigration after a determination by the Board of Commissioners of the existence of the ground for deportation as charges against the alien. The Commissioner of Immigration is also given by legislative delegation the power to issue warrants of arrest. Note, Section 2, Article 3 of the Constitution does not require judicial intervention in the execution of a final order of deportation issued in accordance with law. The constitutional limitation contemplates an order of arrest in the exercise of judicial power as a step preliminary or incidental to prosecution or proceeding for a given offense or administrative action, not as a measure indispensable to carry out a valid decision by a competent official, such as a legal order of deportation issued by the Commissioner of Immigration in pursuance of a valid legislation. Morano versus Vivo GR L22196. Evidence obtained through purely mechanical act. The constitutional right of an accused against self-incrimination prescribes the use of physical or moral compulsion to extort communications from the accused and not the inclusion of his body in evidence when it may be material. Purely mechanical acts are not included in the prohibition, as the accused does not thereby speak his guilt. Hence, the assistance and guiding hand of counsel is not required. The essence of the right against self-incrimination is testimonial compulsion, that is, the giving of evidence against himself through a testimonial act. De la Cruz versus People. Note, no person shall be compelled to be a witness against himself. The constitutional privilege has been defined as a protection against testimonial compulsion, but this has since been extended to any evidence, communicative in nature, acquired under circumstances of duress. Essentially, the right is meant to avoid and prohibit positively the repetition and the recurrence of essentially inhuman procedure of compelling a person in a criminal or in any other case to furnish the missing evidence necessary for his conviction. Thus, an act, whether active or passive, that would amount to disclosure of any incriminatory facts is covered by inhibition of the Constitution. People versus Anacleto. Q. Alvis, GR 710-92. Example of purely mechanical acts. 1. A woman charged with adultery may be compelled to submit to physical examination to determine her pregnancy. Villaflor versus Summers. Number 2. An accused may be compelled to submit to physical examination and have a substance taken from his body for medical determination as to whether he was suffering from gonorrhea, which was contracted by his victim. U.S. versus Tan Teng, 23 Phil 145. Number 3. To expel morphine from his mouth. U.S. versus Ong. Number 4. To have the outline of his foot traced to determine its identity with bloody footprints. U.S. versus Salas. Number 5. To be photographed or measured or his garments or shoes removed or replaced, or to move his body to enable the foregoing things to be done. People versus Otadora. Privacy of communication and correspondence. General rule. Right to privacy of communication and correspondence is inviolable from the 1987 Constitution. Exceptions by lawful order of the court, and number 2, public safety or public order as prescribed by law. Note, any evidence in violation of this right or the right against unreasonable searches and seizures shall be inadmissible for any purpose in any proceeding. Anti-Wiretapping Act, RA 4200. A special law prohibiting and penalizing secret recording of conversations, either through wiretapping or tape recorders. It provides penalties for specific violations of private communication. It shall be unlawful for any person not being authorized by all the parties to any private communication or spoken word to tap any wire or cable, or by using any device or arrangement to secretly overhear, intercept, or record such communication or spoken word by using a device commonly known as a dictaphone or a dictograph or detectaphone or walkie-talkie, tape recorder, or however otherwise described. Intrusion when allowed, exclusionary rule. The right to privacy is not absolute. The right of privacy or the right to be let alone, like the right of free expression, is not an absolute right. A limited intrusion into a person's privacy has long been regarded as permissible, where that person is a public figure and the information sought to be elicited from him or to be published about him constitute a public character. Succinctly put, the right of privacy cannot be invoked to resist publication and dissemination of matters of public interest. The interest sought to be protected by the right of privacy is the right to be free from unwarranted publicity, from the wrongful publicizing of the private affairs and activities of an individual, which are outside the realm of legitimate public concern. Ayer Productions versus Capulong. Note, probable cause in Section 2, Article 3 should be followed for the court to allow intrusion. Particularity of description is needed for written correspondence, but if the intrusion is done through wiretaps and the like, there is no need to describe the content. However, identity of the person or persons whose communication is to be intercepted, and the offense or offenses sought to be prevented, and the period of the authorization given should be specified. A regulation mandating the opening of mail or correspondence of detainees is not violative of the constitutional right to privacy. There is no longer a distinction between an inmate and a detainee with regard to the reasonable expectation of privacy inside a cell. The curtailment of certain rights is necessary to accommodate institutional needs and objectives of prison facilities, primarily internal security. As long as the letters are not confidential communication between the detainee and his lawyer, the detention officials may read them. But if the letters are marked confidential communication between detainee and the lawyer, the officer must not read them, but only inspect them in the presence of detainees. A law is not needed before an executive officer may intrude into the rights of privacy of a detainee or a prisoner. By the very fact of their detention, they have diminished expectations of privacy rights. Alejano versus Cabuay, GR 160-792, 2005. Question. The CSC chairperson, Karina Constantino David, received a letter complaint which said that the employee of the CSC was a lawyer of an accused government employee having a pending case in the said agency. Acting on the matter, she ordered the backing up of all files in the computers found in the Public Assistance and Liaison Division, PALD, of which Bricio Polo was the officer in charge. Drafts of legal pleadings were found in Polo's computer. Thereafter, he was charged with dishonesty, grave misconduct, conduct prejudicial to the best interests of the service, and violation of RA 6713. On his part, Polo attacks the backing up of his files as it was done without his knowledge and consent, thus infringing on his constitutional right to privacy. Is he correct? No. Public employers have an interest in ensuring that their agencies operate in an effective and efficient manner, and that the work of these agencies inevitably suffers from the inefficiency, incompetence, mismanagement, or other work-related misfeasance of its employees. Indeed, in many cases, public employees are entrusted with tremendous responsibility, and the consequences of their misconduct or incompetence to both the agency and the public interest can be severe. In contrast to law enforcement officials, therefore, public employers are not enforcers of the criminal law. Instead, public employers have a direct and overriding interest in ensuring that the work of the agency is conducted in a proper and efficient manner. In our view, therefore, a probable cause requirement for searches of the type of issue here would impose intolerable burdens on public employers. The delay in correcting the employee misconduct caused by the need for probable cause rather than reasonable suspicion will be translated into tangible and often irreparable damage to the agency's work, and ultimately to the public interest. Besides, Polo failed to prove that he had an actual, subjective, expectation of privacy either in his office or government-issued computer, which contained his personal files. He did not allege that he had a separate enclosed office which he did not share with anyone, or that his office was always locked and not open to other employees or visitors. Neither did he allege that he used passwords or adopted any means to prevent other employees from accessing his computer files. Polo vs. David, GR 181881, October 18, 2011. The cybercrime law does not regard as crime private communications of sexual character between consenting adults. The deliberations of the Bicameral Committee of Congress on Section 4, letters C and I of the law show a lack of intent to penalize a private showing between and among two private persons, although that may be a form of obscenity to some. The understanding of those who drew up the cybercrime law is that the element of engaging in a business is necessary to constitute the crime of illegal cybersex. The act actually seeks to punish cyber prostitution, white slave trade, and pornography for favor and consideration. This includes interactive prostitution and pornography, that is by webcam. Disney vs. Secretary of Justice, GR 203335, February 11 of 2014. Right of privacy in social media. To address concerns about privacy, but without defeating its purpose, Facebook was armed with different privacy tools designed to regulate the accessibility of a user's profile as well as information uploaded by the user. It is through the availability of said privacy tools that many OSN or online social network users are said to have subjective expectation that only those to whom they grant access to their profile will view the information they post or upload thereto. This, however, does not mean that any Facebook user automatically has a protected expectation of privacy in all of his or her Facebook activities. Before one can have an expectation of privacy in his or her OSN activity, it is first necessary that said user, in this case, the children of petitioners, manifest the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. And this intention can materialize in cyberspace through the utilization of the OSN's privacy tools. In other words, utilization of these privacy tools is the manifestation in cyber world of the user's invocation of his or her right to informational privacy. Therefore, a Facebook user who opts to make use of a privacy tool to grant or deny access to his or her post or profile detail should not be denied the informational privacy right which necessarily accompanies said choice. Otherwise, using these privacy tools would be a feckless exercise, such that is For instance, a user uploads a photo or any personal information to his or her Facebook page and sets its privacy level at only me, or a custom list so that only the user or a chosen few can view it, said photo would still be deemed public by the court as if the user never chose to limit the photo's visibility and accessibility. Such position, if adopted, will not only strip these privacy tools of their function, but it would also disregard the very intention of the user to keep said photo or information within the confines of his or her private space. Vivares versus St. Teresa's College. Reasonable expectation of privacy test. This test determines whether a person has a reasonable expectation of privacy and whether the expectation has been violated. In Opel versus Torres, we enunciated that the reasonableness of a person's expectation of privacy depends on a two-part test. That is, 1. Whether by his conduct the individual has exhibited an expectation of privacy, and 2. This expectation is one that society recognizes as reasonable. There is number 3. 3. Customs, community norms, and practices may therefore limit or extend an individual's reasonable expectation of privacy. Hence, the reasonableness of a person's expectation of privacy must be determined on a case-to-case basis, since it depends on the factual circumstances surrounding the case. Opel versus Torres, GR 127685, July 23, 1998. Question. Spouses Hing were owner of a parcel of land, and Aldo Incorporated constructed an auto repair shop building on the adjacent lot. Aldo filed a case for injunction and damages claiming that the spouses Hing were constructing a fence without valid permit and that the construction would destroy their building. The case was dismissed for failure of Aldo to substantiate its allegations. Aldo Incorporated then installed 2 cameras on their building facing the property of the spouses Hing. The spouses contend that the installation of the cameras was an invasion of their privacy. Is there a limitation on the installation of surveillance cameras? Yes. In this day and age, video surveillance cameras are installed practically everywhere for the protection and safety of everyone. The installation of these cameras, however, should not cover places where there is reasonable expectation of privacy, unless the consent of the individual whose right to privacy would be affected was obtained. Nor should these cameras be used to pry into the privacy of another's residence or business office, as it would be no different from eavesdropping, which is a crime under Republic Act 4200 or the Anti-Wiretapping Law. Spouses Hing versus Chua Chui, GR number 179736, June 26, 2013. Prohibited acts under the Anti-Wiretapping Law. 1. To tap any wire, cable, or by using any other device or arrangement to secretly overhear, intercept, or record such communication or spoken word by using a device commonly known as a dictaphone or dictograph, detectaphone, or walkie-talkie, or tape recorder, or however otherwise described by any person not being authorized by all the parties to the private communication or spoken word. To knowingly possess any tape record, wire record, disc record, or any other such record, or copies thereof, or any communication or spoken word secured either before or after the effective date of this act in a manner prohibited by this law. 3. To replay the same for any other person or persons. 4th, to communicate the contents thereof, either verbally or in writing. Or 5. To furnish transcriptions thereof, whether complete or partial, to any other person. Under Section 3 of RA 4200, a peace officer who is authorized by a written order of the court may execute any of the acts declared to be unlawful in Section 1 and Section 2 of the said law in cases involving the crimes of treason, espionage, provoking war and disloyalty in case of war, privacy and mutiny in the high seas, rebellion, conspiracy and proposal and inciting to commit included, sedition, conspiracy, inciting included, kidnapping, and 8 violations of CA 616 or punishing espionage and other offenses against national security. The use of telephone extension is not a violation of RA 4200. The use of a telephone extension to overhear private conversation is neither among those devices nor considered as a similar device prohibited under the law. Gahanan versus IAC, GR number 69809, October 16, 1986. Forms of correspondence covered: letters, messages, telephone calls, and telegrams, and the like. Question: Esther S. Garcia, in a confrontation with Socorro Ramirez, allegedly vexed, insulted, and humiliated Ramirez in a hostile and furious mood and in a manner offensive to Ramirez's dignity and personality. Ramirez then filed a civil case for damages against Garcia. In support of her claim, Ramirez produced a verbatim transcript of the event. This transcript on which the civil case was based was culled from a tape recording of the confrontation. As a result of Ramirez's recording of the event, Garcia filed a criminal case for a violation of RA 4200, alleging that the act of secretly taping the confrontation was illegal. Ramirez contends that the facts charged do not constitute an offense. Was there a violation of RA 4200? Yes. The unambiguity of the express words of the Parisian taken together with the above-quoted deliberations from the Congressional Record, therefore plainly supports the view held by the respondent court that the provision seeks to penalize even those privy to the private communications, where the law makes no distinction, one does not distinguish. The nature of the conversations is immaterial to a violation of the statute. The substance of the same need not be specifically alleged in the information. The mere allegation that an individual made a secret recording of a private communication by means of a tape recorder would suffice to constitute an offense under Section 1 of RA 4200. As the Solicitor General pointed out in his comment before the respondent court, nowhere in the said law is it required that before one can be regarded as a violator, the nature of the conversation as well as its communication to a third person should be professed. The phrase private communication in Section 1 of RA 4200 is broad enough to conclude verbal or nonverbal written or expressive communications of meanings or thoughts which are likely to include the emotionally charged exchange between petitioner and private respondent in the privacy of the latter's office. Ramirez versus CA.